Good day. It is me again. And today, oh, forgot my earphones. That's better. Okay, today we're going to look at the doctor or the hospital doctor-hospital patient relationship. Where does it start? What does it entail, etc. So, yes, I'm going to share my PowerPoint with you, and then I will talk you through that. So, once again, please just forgive my bad English and forgive me when I struggle a little bit with technology, but I'm trying my best. Okay, let's see. There we go. From the beginning. Okay. So yes, by now you know that I am Professor Martha Slabbert. So this is the third recording that you are going to view. And today this is the doctor-patient relationship or the hospital-patient relationship. Okay, first of all, in the previous recording, I told you that when you institute action for an alleged medical negligence, you can do it on the basis of a contract, a delict, or on both. And last time I gave you the requirements of a delict. You can see it's there below on the slide. There must be conduct. The conduct must be wrongful. The person must have suffered damages. There must be causation between the conduct and the damages. And then there's fault. Fault can be intention or negligence. In our scenario, we will only focus on negligence. And then I said in the previous recording, can you still remember the requirements for a contract, which are, of course, consensus, capacity to act, physically possible, legally possible, and then also damages. So if you sue on the basis of a contract, then all these requirements must be there. If you put a claim against a person on the basis of a delict, then all the requirements for a delict must be there. There is basically just one example that's a good example that you can follow up, and that is administration of Natal versus Edward. And that case was adjudicated on the basis of a contract, that they did not comply with a contract. Just a few general comments. You will see administrator of Natal. Of course, that is in the old South Africa before we had the 9 provinces. Natal was one of the provinces, and the head of the province during that time was known as the administrator. Nowadays, we have 9 provinces, and at the head of a province, we have a premier. So you can see it's quite an old case, 1990. So that is before the New South Africa, and the A at the end then indicates that it went to the Supreme Court of Appeal, which was the appellate division at that stage. So what happened in that case is that the woman went for a sterilization in the public sector, and the sterilization was not done well, and she fell pregnant again. So then she sued the administrator, the head of the province, because the people in the public sector in that province are employees of the state. So she sued them because she didn't want another child, and now she fell pregnant again because the sterilization was not performed adequately. And then she said that the administrator of Natal, being the employer of the people working in the public sector, has broken the contract that was between herself and the hospital in order to be sterilized. So she claimed on the basis of a contract that the contract was broken between herself and the public hospital, and because of that, she fell pregnant, and she claimed the upbringing cost of the child. She could not claim non-patrimonial damages because that is not a possibility when you sue on the basis of a contract. So let me go back. When you sue on the basis of a delict, then you can claim everything. In other words, past medical costs, future medical costs, loss of amenities of life, and pain and suffering. But if you claim on the basis of a contract, you can claim the damages that you suffered, but you cannot claim pain and suffering, non-patrimonial issues. So that is very important, and that is why the majority of cases being adjudicated for alleged medical negligence will be on the basis of a delict, because then you can claim non-patrimonial damages, pain and suffering. You cannot do that on the basis of a contract. So if we go back to the Edward case, she could claim the upbringing cost of the child that was there, that shouldn't have been there because she should have been sterilized. But she herself could not claim pain and suffering for the whole pregnancy because she only alleged that a contract was broken and it was not on the basis of a delict. Then I want to draw your attention to a very interesting case, Afrox versus Strydom. It's 2002, in other words, in the New South Africa. Afrox is the name of a hospital group. They are now known as Life. But it's a hospital, and this guy sued them, and then it was taken to the Supreme Court of Appeal, and the hospital group then went on appeal, and the appeal was successful. That case concerns exclusionary clauses on hospital admittance forms. So that is why at the beginning, or the heading for this recording, is the relationship between a doctor and a patient, but also a hospital and a patient. And that case is very important because Mr. Strydom alleged that the clauses in the admittance form that say that the hospital could not be held liable for any things that go wrong during his stay in the hospital, whether negligently or intentionally. And he said that that could not happen, that should not happen, and they are not on equal bargaining because he's an individual and they are a hospital. But the court gave judgment in favor of the hospital, saying that the exclusionary clauses in the admittance form is legal and valid and must stay there. This is very interesting, and I apologize. If you go and find the case to read it in detail, it is only reported in Afrikaans. I've got no idea why, and I apologize for that, but that is the case, that it is only reported in Afrikaans. But if you Google it, you will get a lot of summaries explaining to you what happened there. And then, of course, that is in English. The question now is that would this the judgment have gone the same way if the Consumer Protection Act was already effective? The Consumer Protection Act came after the judgment of this case. So currently, because the exclusionary clauses in a hospital contract has not been declared illegal or invalid, it is still valid today. So it is still there. Someone must now take it to court again and challenge it, but then challenge it not on the pure basis of a contract, but on the Consumer Protection Act. And then I believe the judgment will go a different way. Okay, there you just see once again the requirements for a delict. But let's focus on a contractual relationship. First of all, there need to be consensus. In other words, the patient must go to the doctor and wanted to be treated by the doctor. The doctor must be willing to treat the patient. Then we say there is a coming together of the minds and there is consensus that the doctor will treat the patient. Then, of course, if you want to sue on the basis of a contract, then the contracting parties must have contractual capacity. And just briefly, that adults have full contractual capacity. Adults meaning every person above the age of 18 who is of sober mind and in healthy mental condition, that knows what is right or what is wrong. Those are adults and they have full contractual capacity. Then minors are those below the age of 18, but as I've also said, that they must be assisted by their parents, but keep the Children's Act in your mind, because the Children's Act say that a minor of 12 or older who are mature enough to understand everything can consent to medical treatment and surgery. So keep that in mind concerning contractual capacity. And then, of course, the mentally ill, they do not have contractual capacity if they are mentally ill, but it will depend on the facts of the case, whether that person was mentally ill or not at the time when the contract was concluded. Now, where does the law of contract and delict comes from? So South Africa has what we call the common law. And the common law comprises of law of non-statutory origin. In other words, there is no act explaining how a contract worked. There is no specific act with a number and on paper that you can go and read about a delict. They are non-statutory. In other words, they are not documents of legislation. They are just part of our inheritance of our legal system, what we call the common law. Now, in South Africa, basically our common law comprises of Roman law, Roman Dutch law, English law, and then certain parts of indigenous law. Those are the legal system not written down, but has been part of our legal system forever. So an obligation gives rise to the right of one party to claim the performance of another party. That is an obligation. So one party has a right to expect certain performance from another party. And that is the main sources of the common law of obligation, the law of contract, and the law of delict. In the contract, we conclude, I say I will do this, and that is what you wanted. We have contractual capacity, we've reached consensus, then we can conclude a contract. A delict is the act of a person that is wrongful and culpable in a culpable way that gives rise to a harm to another person. As I've said previously, two individuals, the one harmed the other suffered damages, then a delict happened. Okay, so a delict, also under the delict, is that all medical practitioners are required to exercise reasonable care and skill when they provide treatment. That is not in a specific law. That is the law of delict, that it is expected from all medical practitioners when they are involved with a patient to exercise reasonable care and skill and to look at that person to the best of his or her ability. That can also be drawn through to the Hippocratic Oath that doctors take before they start practicing, where they promise that they will look after a patient and they will not harm the patient. So all of that forms part of the law of delict. So just to recap, when something went wrong, and the person wants to start litigation because of alleged medical negligence, then the lawyer has a choice to sue on the basis of a contract, but then you can just claim actual damages, or you can sue on the basis of a delict. Then you will claim actual damages, future damages, and pain and suffering. Or you can claim on both. So you need not just go the one way, you can go both ways. But if you go on the basis of a delict, you must comply with all the requirements of a delict. The most difficult thing to prove in a delict is causation. If you go on the basis of a contract, then you must prove your actual damages that you have suffered. Okay, so let's go forward. Is there a duty to treat on doctors? The answer is yes and no. There's no clear yes or no. As I've said in the previous recording, that when you work in the public sector, then you are an employee and you've got a contract of employment and you have to treat everyone that presents him or herself to you. So you do have a duty to treat. In the private sector, I have said that doctors are independent contractors and they can decide who they want to treat and who not. So they have a lesser duty to treat. But both, whether in the public sector or in the private sector, remember the Constitution say that everyone has the right to emergency medical care. In other words, if an emergency presents to you as doctor, then you have a duty to treat, whether you're in the public or the private sector. Just quickly, a side note. When there's an accident and the people are severely injured, it's a question of life or death, then the ambulance should go to the nearest hospital, whether that be public or private. If it is a private hospital and it is established that the injured person does not have a medical aid, the hospital has a duty to stabilize the patient to such an extent that he or she can be moved to a public hospital. In other words, the private hospital does not have the right to say, we're not going to treat this person because he or she doesn't have a medical aid fund. They have a duty, according to the Constitution, the right to emergency health care. Therefore, there is a duty to treat the injured person, stabilize him or her, and then when it is convenient and in the best interest of the patient, that patient can be moved to a public hospital. Is there a duty to complete the treatment? Yes. Once a doctor has started treatment to a patient, he or she has a duty to complete it. In other words, a doctor cannot abandon a patient. They have a duty to complete the treatment. If they cannot, for some or other reason, complete the treatment, then they must hand the patient over to someone competent to complete the treatment. In other words, you cannot just decide you are now fed up with this patient and just leave the patient. You have to complete the treatment. If you yourself cannot do it, you must refer the patient to someone who can complete the treatment. Is there a duty to get informed consent? This is extremely important. Yes, yes, yes. You have to get the informed consent of a person before treatment can start. You have to get informed consent. It goes back to when I discussed the Constitution. It goes back to the right of self-determination. It also refers to autonomy when we speak of bioethics, the right to decide for yourself. So there is a duty. If you treat a patient without the patient's informed consent, then it can be seen as culpable homicide, that you hurt the patient because the patient did not give informed consent. So this is extremely important. How do we know what is informed consent? If you go to the case of Castell versus de Greef, you will see it's quite an old case, but in that case, it is specifically stipulated what does informed consent means. It basically means that the doctor or the hospital must give you all relevant information, all the risks, all the benefits, all the treatment options, everything possible, so that you as a patient can decide whether you want that treatment or not. That is very important. And some doctors are lacking here. They just give you a brochure and they say, go and read it, and then they expect that is good enough for informed consent. That is not good enough. The doctor will have to discuss the brochure with the patient to make sure that the patient understood everything in that brochure. In order to get informed consent, the facts or the risks or the benefits or the alternatives must be explained to the patient in a language that that patient can understand and on a level of intellect that that patient can comprehend everything and then take a decision. But you will get everything. And if you read through new medical negligence cases, you will see that they constantly refer back to Castell versus de Greef. Therefore, that can be seen as the locus classicus, the case that you need to quote, the case that you need to read when you are faced with possible litigation, and the claim is that the patient did not give informed consent. Then also in the National Health Act, you will find in section 6, 7, 8, and 9, where consent is also addressed and where it is explained what happens in emergencies when the person self cannot give consent. Who then should give consent, and how does it work? So that is extremely important to look at the National Health Act as well. Also, consider the Consumer Protection Act, because a patient under that act is seen as a consumer and the doctor as a service provider. And even in that act, it is stipulated how to get informed consent. Same as what I've said, it must be in the language that the person understands, on the level that the person understands. All the pros, all the cons, all the risks, all the benefits, all the alternatives must be explained to the patient before treatment starts. You can also go to the Health Professions Council of South Africa, to their website, and in booklet 4, you will also see what are the requirements for informed consent that doctors or anyone registered with the HPCSA should follow. The cases that I've listed there is first Isaacs versus Pandey, and then it went to the Supreme Court of Appeal, and then it is Pandey versus Isaacs. What happened there is there was confusion concerning sterilization. Now, usually informed consent need not be in writing, although it is much better to have it in writing, because if there's a dispute afterwards, you can go back to the document where the person signed. The doctor must also make a note on the file of the patient that he or she discussed all the things with the patient and the patient were informed and the patient gave consent. What happened in Isaacs versus Pandey, as I've said, sterilization. But in order to give consent to a sterilization, it must be in writing, because the Sterilization Act say that permission for a sterilization must be in writing. But there was a bit of a confusion in those cases whether she gave permission for sterilization or not. So that cases will also help you to understand informed consent better. In the RB versus Smith case is also concerning informed consent. 2 procedures were possible to do on the patient. Then the doctor discussed the one procedure and he eventually did the other procedure. There was no specific form where they could see that the patient understood everything and the signature was there. So it was basically the doctor's word against the word of the patient, but then judgment was given in favor of the doctor. So once again, my opinion with respect to the judgment, it is not that clear when you read the case whether it is per se the doctor that is on the right side versus the patient. But it is a very nice case to go and read to see how they argued. But the patient gave consent and the patient said, yes, but I gave consent for another procedure, etc. So informed consent, very important. And if ever you are faced with a case like this, these cases will give you guidelines as well as the Act and the booklet of the HPCSA. Okay, so what are the doctor or the hospital's duties towards a patient? As I've said, it is to inform the patient so that the patient can give informed consent. The patient must be informed of all the procedures that's going to happen, the pros and the cons, the risk of it, etc. Just as a side note, a personal experience. So my sister had to go for a foot operation, and the anaesthetist came before the operation and explained everything about an epidural to my sister. My sister did not know anything about it, but the pros, the cons, and everything was explained to her, and my sister gave consent for an epidural to be performed on her. She was going for a leg operation. But what is interesting, when she came out, there were some consequences and some bad things happened, etc. And then we realized that the anaesthetist deviated. She got consent for an epidural, but then she administered a block, a spinal block. Now, there's a lot of difference between doctors that say it's more or less the same thing. My conclusion is it's not the same thing. So my sister was not informed of the consequences or the procedure for a spinal block. And therefore, according to me, she did not give informed consent. But fortunately, she suffered no damages, so we could not institute an action. But this is just to indicate to you, it seems logic that a doctor will explain everything and get informed consent, but it sometimes doesn't happen. And especially also when you go to physiotherapists, they must tell you that they're going to follow this program. If they then, in a few weeks' time, want to follow a different program, they must get informed consent again. So there's nothing like blanket informed consent that you can do with me what you want. There must be informed consent for every procedure. The anaesthetist must get informed consent. That the surgical team must get informed consent. You must give informed consent to the hospital. Those things are all important, and every person must be given a chance to ask questions, to get as much information as possible before they consent. Okay, so the doctor must inform the patient. The doctor must get the patient's consent. Of course, there is confidentiality between a doctor and a patient, and that links again with our constitutional right to privacy. Then the doctor must perform his treatment or her treatment with skill and care to the best of their ability, according to their training, etc. And then, as I've said, they must complete it. There's a duty on them. Once they start a treatment, they have to complete it. If they can't personally complete it, then they must hand over the patient to another doctor who can complete the treatment. What are the duties of a patient? Of course, the patient must comply with the treatment proposals and prescribed by the doctor. In other words, if the doctor say you have to drink that or that medicine, then you have to. If you don't and something goes wrong, then you add it to the negligence and you can be found guilty of contributory negligence. So you have to follow what the doctors say. Compliance with the physiotherapy after an operation. Compliance with the wound dressing after you went for an operation. Because if you do not comply with what the doctor said, then, as I've said, you can become guilty of contributory negligence. Then the patient must be honest. What does this mean? This means that when you go to a doctor for treatment, you must be honest and tell the doctor, for example, if you are taking chronic medicine, if you are aware that you have certain conditions. So the doctor cannot treat you if you are not honest. So let's say, for example, you know you are a diabetic, but you don't tell the doctor, and now the doctor prescribes some medicine for your other illness, but that medicine and the medicine from your diabetes do not gel well together. So you must be honest. Remember, there's confidentiality between a doctor and a patient, and therefore a patient must reveal everything to the doctor in order for him or her then to treat you to the best of his or her ability. Then, of course, the patient must respect the doctor. And one can say that is taken for granted, but you get bad patients as well. So respect the doctor or the nurses or the people treating you. Sorry, I'm just drinking water. And then, of course, it is the duty of the patient to pay the fees. And here I just want to mention something. If you have medical aid, that is a separate contract, and that medical aid is not part of the contract between you and the doctor. So the patient has the duty to pay the doctor. If you have a medical aid, then your medical aid will pay the doctor. But if the medical aid does not pay the doctor, you stay personally liable for the payment of the doctor. So there's no agreement between the doctor and the medical aid. The agreement is between you or the patient and the medical aid, and there's another agreement between the patient and the doctor. So if a medical aid does not pay the costs in full, it is the patient that will stay responsible for that duty. Also, doctors can invoice you if you do not honor an appointment. They have the right to do that within reasonability. But if that happens and you are furious, then just know that they have the right to do that. If you just did not show up for your consultation, or you did not notify them that you could not make it, then they have the right to charge you for that appointment that you made. Okay, so those are the duties of a patient. So this recording is much shorter, but you have to go to your study material, your theory, where everything that I've briefly touched on now is there. And then you must study the theory. Remember, the theory in this unit is also relevant for test 1. Okay, so let's just quickly see practical exercises, what around the doctor-patient relationship, etc. So a woman consults a gynecologist on the day that she wanted to deliver her, or that the baby was going to come. Her gynecologist was not available. So as I've said, a doctor must complete the treatment. So the gynecologist, knowing that he will not be there if the baby comes, he went to a colleague and he asked a colleague to stand in for him. Should the woman go in labor, then the colleague must please assist her. And then that is exactly what happened. He left, And then the baby was coming, and the stand-in doctor was notified that this woman is now in labor. He just gave instructions over the phone for the nurses to stabilize her, to monitor the fetus, to do everything that is necessary before a baby is born. But he was called again, and he gave instructions, and then he showed up much later at the maternity ward, and a baby was born. Unfortunately, things went wrong. The baby suffered an oxygen shortage, and therefore the baby was diagnosed with cerebral palsy. Now, the question to ask here is, when did the doctor-patient relationship start between the woman giving birth and this stand-in doctor? Of course, there was a doctor-patient relationship between herself and her gynecologist. So that is fine, and we've got no problem with that. As I've said, a doctor has a duty to complete the treatment, but her gynecologist wasn't available when she gave birth, but he took precautions, and he organized with a colleague to stand in for him should this woman give birth. The colleague stood in. He was there. Now the question is there a new relationship between the woman giving birth and this stand-in doctor? Yes, there should be a doctor-patient relationship because he was going to treat her. But when did it start? With the original gynecologist, it's easy to determine when the relationship started, as it started the day she went to the doctor, and the doctor said she was pregnant, and the gynecologist said, okay, I will take you through this whole process. So that is no problem. But where did the doctor-patient relationship start with the stand-in doctor? Now, if you read the Life versus Suleiman case, you will find the answer there. It is unclear, and once again, the court interpreted it in different ways without giving clear direction. And therefore, I leave it open to you. What do you think? When did it start? Did it start the moment when the original gynecologist consulted the colleague and asked for him to stand in? Did a new relationship, doctor-patient, start there? Or did it start when the nurses called the stand-in doctor and explained to the stand-in doctor over the telephone the condition of the woman giving birth? Did it start there? Or did it start when he physically showed up at the maternity ward to assist the woman? Did it only start there? There's no clear answer, and whatever one you choose, you should just be able to motivate why you chose that option. The reason I'm giving you this exercise is only to show to you that it is not always that easy to exactly determine, was there a doctor-patient relationship and when did it start? If we look at the second one, Dr. Y has been working for a partnership of doctors for the past 2 years. He is paid per hour, and they subtract pay as you earn. There is no formal contract. One day, there's a misdiagnosis by Dr. Y acting in the employment of the partnership. The patient dies. Dr. Y is held responsible, but he has no insurance. What now? Can you remember in the first recording, I said that medical law is absolutely fantastic because it overlaps with so many other legal fields. And this is now an example of this, because labor law comes into play here to a certain extent. So let's analyze the facts. Dr. Y has been working for a partnership. If you know anything about labor law, you will remember that a partnership is not a legal entity and that the partners are responsible for all losses and they share in all profits, but they do not have um, 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 uh, they're not an entity, a legal entity, or a juristic person. They stay the natural people, the partners of the partnerships. So he has been working for them for the past 2 years. He gets a salary and they subtract tax. And that is an indication of an employee. If you do the test that you've learned in labor law, when is a person an employee or when is he or she an independent contractor, then you will see if you are paid a fixed salary and the person subtracts tax on a monthly basis, then it is more or less an indication that that person is an employee. Remember, there need not be a formal contract of employment. It's always good to have it in writing, but it needn't be. So the fact that there was no formal employment contract is no problem. Okay, so Dr. Y acted in the scope of his employment when the patient died. So what should happen now? Of course, the family or the spouse of the patient will now sue Dr. Y because the patient died. He alleges there was negligence and therefore Dr. Y will be sued. But what can Dr. Y do? Dr. Y can, of course, say that he is an employee of the partnership. And because he's an employee, then vicarious liability, the employer becomes responsible for the actions of the employee. Therefore, the partnership should be sued. Dr. Y will argue that he was an employee and therefore his employer, the partnership, should be sued. Okay, the partnership then is not a legal entity, therefore all the partners in their individual natural capacity will be sued. And what is also important is that Dr. Y has no insurance. Every doctor practicing must have insurance. Because if things goes wrong, then the insurance will pay out. But Dr. Y has no insurance. So that's an oversight of the partnership. They should have checked that Dr. Y had insurance when they started using him in their partnership. So the end will be that the spouse of the patient who died will be able to sue Dr. Y plus all the partners in the partnership in their natural capacity. Okay, so I hope you found that interesting. And that is the end. This is a short recording. But it is very important to understand the doctor-patient relationship, when it starts, what are the consequences, what are the duties of the doctors, but equally what are the duties of patients. So this is the end of this recording. Then we meet again in the next unit. Thank you.